SJC-12648, Joseph Walsh and another, v. Commonwealth.
Mr. Griffiths, good morning.
Good morning, Chief Justice Gantz. May it please the court, Darren Griffiths on behalf of Mateus Diamond. I'm here to address the LaValle claims in this case. This case is symptomatic of a recurring failure of our judicial system here in the Commonwealth. It's a failure that reveals a stark contrast between the ideals professed in this court's decisions about the right to counsel and the reality in which the legislature has routinely and repeatedly refused to fund a system that adequately safeguards the rights of the accused. The legislature has abdicated its duty to protect the rights of the accused under Article 12 and the Sixth Amendment to the Constitution. This court does not have that option. This court has a duty to make sure that there are adequate numbers of attorneys to zealously represent the rights of the accused and to provide a real and enforceable remedy for defendants who are deprived of liberty without the effective assistance of counsel. It seems a system that we've been working with here in the Commonwealth is always teetering at the precipice of a serious constitutional crisis, and the system has repeatedly tipped into a state of serious constitutional deficiencies, where criminal defendants are deprived of their liberty and denied the right to effective assistance of counsel. When the system tips into chaos, when that precarious balance is knocked sideways, it's the accused who pay the price. They pay for the dysfunction of the system, and that there's no doubt that those costs of a dysfunctional system are very real.
Can we look at the actual numbers?
Yes.
So Justice Lowy kicks this back, and then we find that out of 181 cases, 31 were not assigned counsel at arraignment. In regards to the defendant who went out unrepresented, it took an average of 5 days to assign counsel. The overall time span it took to assign counsel was between 0 and 14 days. Are those numbers right?
I believe those numbers are right for the first part of fiscal year 2019.
Okay, so has creative management by CPCS actually made this a workable system right now?
So it is, at this point, functioning, I think, better than it was back when this crisis first emerged. However, it's still not a perfect system by any stretch of the imagination, and there's still...
Well, we don't live in a perfect world, but...
Right.
So...
Well, I guess my point is, it's not only imperfect, but it is a system that is precarious in that if there are just subtle changes or subtle shifts in the alignment of counsel or the number of counsel willing to take Superior Court cases, if there's a significant increase in for example, the number of dangerousness hearings that are requested by the Commonwealth, that sort of delicate balance, the sort of stasis that we've reached at this point is going to be thrown off kilter, and we're going to be back into a situation where we're going to be faced with defendants who are unrepresented for a period of time. I think while the average number of days, I think, it was 5, according to the numbers from the first part of fiscal year 2019, I think it's significant that there were 8 defendants who waited more than, or at least 8 days to have counsel assigned to them. That's a significant number, 8 defendants within that time period, within the first half of fiscal year 2019. That's, just that number alone represents, I think, a significant cost that is borne by the defendants who are subject to
trajectory. I don't remember from Judge Kenton Walker's findings if she talked about trends overall, but it seems like the trajectory is toward more 58 days in Worcester County, isn't it?
That's correct.
And a number of the amici, they made the point that not funding adequately public counsel for indigent defendants has public safety concerns as well, and a number focused on 58A hearings particularly. So when you're talking about the amount of days it takes before you have some representation, you also bump into the limits of the statute, which I believe is a 3-day continuance for the Commonwealth.
That's correct, Your Honor.
Okay.
And I think it's, so in Worcester County, between fiscal year 2016, when there were 54 dangerousness hearings sought in the Superior Court, that number grew to 111 in fiscal year 2018. So that's over double the amount of dangerousness hearings, and that puts a serious strain on the system that we're talking about.
You agree that that's a result of a shift away from using the bail statute to detain people, and so the Commonwealth moves for more dangerousness hearings? Is that what's going on?
Well, I think there's a confluence of factors actually in Worcester County. I think it was at least in part a reaction to this court's decision in Brandon. I don't think there's any argument about that. But there were also other factors in play, including a couple of high-profile cases in which defendants who were out on bail committed serious offenses that got a lot of press attention, and I think that played a part in the district attorney's office decision to seek more dangerousness hearings in those types of cases.
Well, Brandon might be impacting 58As, but it absolutely shouldn't be impacting 58As, because can't use risk of flight in a high bail for preventative detention.
I don't disagree with that whatsoever.
Should be no impact.
I don't disagree. I don't disagree. But I think the numbers speak for themselves in this regard.
So what do you, I'm sorry. No, go ahead. There you go.
Okay. So what do you say we do?
So I think there are a couple of different remedies here. I think first of all, and this came out in the hearings before Judge Kenton Walker in the Superior Court. I think she was in the back of her mind, she thought there's this LaValle remedy that I know about, and maybe that this LaValle remedy should be the remedy for people who find themselves in this, or defendants who find themselves in this situation. But I think it's clear from reading the transcript of that hearing from October 5th that she didn't feel that LaValle was a remedy that was necessarily something that she could impose in this particular situation. So I think this court should make it clear that LaValle is sort of a remedy that can exist when people are held for a period of time without counsel, when they're deprived of their liberty without counsel. And then beyond that, I think that this court could take steps sort of beyond that and address the larger funding issues that I think others that are here today will be talking about as well.
But I mean, LaValle, people focus on LaValle as speaking of the release of an individual after 7 days who has been held for dangerousness where there is no counsel, and dismissal without prejudice after 45 days. But it's also a more detailed protocol that requires the involvement of the Raj and weekly reviews. I mean, it's a considerable administrative burden to be determining what's going on, and the question, I guess, is does the situation in Worcester at this time justify the implementation of that kind of burdensome protocol?
At the current moment in Worcester, I don't think there is the type of situation that calls for LaValle, but I think, as I said before, I think we can very easily reach that point where that becomes necessary again. And I think the LaValle protocol could be modified to sort of streamline this process a little bit so that when there is a situation that the courts become aware of, because everyone in Worcester County was aware that this was a problem at the time that this sort of came to the fore. I think there are ways of streamlining LaValle to make it workable, but I think really what LaValle and what making clear to everyone who's involved in the system that LaValle is a real remedy that can exist, I think what that's going to do is it's going to prompt action on behalf of the other stakeholders in this system, the legislature and others, to take action to make sure that LaValle protocol does not actually have to be implemented for situations like this one.
So I'm trying to sort of sort out, are you essentially saying that the Superior Court Raj, or for that matter, the Superior Court Chief Justice would be able to petition the single justice of this court and essentially ask for a LaValle remedy or a LaValle type remedy to be imposed based on some type of showing?
I don't even think it has to be that complicated. I think they can, if a Raj or the Chief Justice makes a determination that a crisis like the one that we were experiencing in Worcester exists, I think they can then make the determination that the LaValle protocol needs to be implemented, and those steps need to be.
Who determines whether there's a crisis?
Well, I think when there are, I think the crisis is going to be obvious. I think it's going to be when there.
Who determines that?
I think the Superior Court would make that determination in conjunction with CPCS and the other stakeholders who are responsible for making sure that people have counsel assigned to them.
Does the Raj then look to CPCS and say, what are the real caseload issues here?
I think there is.
The Raj just say, you say there's a crisis, so there's a crisis.
Well, I don't think there's ever been any issue with CPCS being transparent about their caseload and how they're managing that caseload. And I think here in this case, the head of the CPCS office in Worcester was in close communication with Judge Kent Walker about the staffing levels and why they were experiencing problems with the staffing in the CPCS Public Counsel Division, and why there were problems is, Judge Kent Walker was also in close contact with the Bar Advocate Program about why there are issues having sufficient numbers of Superior Court counsel who could take these cases as well.
Now, the briefs speak of two forms of delay. One is the form of delay of CPCS not being able to locate a bar advocate or have the availability of a public defender to do it. But there's also some period of delay in terms of the clerk notifying the bar counsel, the bar advocate office of the need for counsel. And I don't understand what the reason is for that type of delay.
To be honest, and I don't have insight into what the cause of that delay is, but I do understand from all of our work on this case that the delay can be significant, sometimes up to 2 days before the Bar Advocate Program learns of the fact that this counsel needs to be assigned. Obviously, I think that's something that the trial court needs to take a look at in terms of administrative processes for making sure that that someone does not experience a delay in having counsel assigned to them because of just an administrative communication issue.
And going back to Justice Gaziano's question, how would you define a crisis?
I think I would define it as any time there are defendants who are held without counsel for longer than, in a 58A situation, 7 days. Because I think even the deprivation for even one individual for longer than the statutory period is a serious deprivation that impacts their constitutional rights and also seriously impacts their ability to defend themselves going forward, and it impacts, obviously their lives as well.
Okay, but I mean, the difference is that the protocol is designed to prevent that 7 days from happening. The protocol is designed to be on top of everything so that you don't fall into a 7 days. Are you saying that every time there's more than 7 days, regardless of who's at fault, that would trigger LaValle?
I think at that point, the Raj or the Chief Justice would have to take a look and see whether or not the LaValle protocol needs to be implemented at that point. I think that's a warning sign, basically.
Okay. Mr. Schnipper.
Good morning. May it please the court. Merritt Schnipper. I'm here with my co-counsel, Robert Hennessy, on behalf of Joseph Walsh, and I'll be addressing the conditions of release claims Justice Lowy reported on behalf of both defendants. I think 2 years into Brangen, experience has shown that clear procedures are still needed to ensure that people are not detained on unaffordable bail unless the court actually determines they're a risk of non-appearance for further proceedings, and there's no other way to ensure that they return to court. If we look at the Mass Trial Court study from earlier this year, it still shows that 40% of people subject to any amount of cash bail remain held. That tells us that either there's a absolute epidemic of people who are not showing up for court hearings, which I don't think is the case, or it tells us that bail amounts are not being set with adequate sensitivity to find amounts that people can afford to be released and not be detained for the sometimes year or more it takes to resolve their case. I think what we're asking for from this court is greater clarity in the procedures that judges should employ, and we're asking for a specific order in which the courts should engage in the inquiry they need to do. The first thing that they need to do is they need to determine whether the presumption of release on personal recognizance that's contained in the bail statutes has actually been rebutted. That burden needs to be on the Commonwealth to rebut that in each individual case. And the judge needs to find that it's been rebutted in each individual case before we even move on to seeing what other conditions of release might be appropriate.
Can you go through, not in detail, but the form that you're very familiar with?
Sure.
Why that's inadequate and what needs to be done with respect to findings?
Sure. I mean, I think the most inadequate thing is that it does not contain a place to say the presumption of recognizance has been rebutted and why and how, through what evidence. It does not contain a place in which the judge basically can say, here are the non-cash conditions that I've considered. It basically has the reasons I did what I did.
Right, isn't inherent in the finding that they're gonna set bail, is that the presumption of?
Well, it may be inherent in the finding, but there's no way to look beyond that by a reviewing court in the case of a bail review to figure out why.
Right, because I'm looking, because the judge has a statute, clearly there's the presumption, and the judge says, no, I'm not going to release you on your own recognizance, i.e. the presumption's been rebutted.
Right.
For these reasons, you don't show up. In your mind, it has to be more explicit than that.
I do think it does need to be, and of course it can be on the record orally, it doesn't need to be.
Right, that's not an issue.
So it needn't be a burdensome undertaking, but the bottom line is that every person appears at arraignment presumed to be released subject to their own recognizance. So first, I think some finding of why that's been rebutted. The next step should be, let's look at non-cash terms, because non-cash terms don't implicate wealth-based detention at all.
Why don't we do it in a specific example, for example, your client? So, I mean, we have findings in this case, right?
Sure. Well, we have some findings.
And, you know, the judge then, in follow-up to Justice Lowy's questions, makes further findings, right?
Sure.
So why isn't that adequate here?
Well, just to take the specifics, the judge had before him, although he didn't refer to them, the indigency form that was necessary to result in the assigned counsel issue that you already heard about.
Right.
That showed that Mr. Walsh was living in a two-person household on an income of less than $21,000 after taxes. So it might be reasonable to ask how a judge came up with $7,500 bail amount, in other words, a third of the after-tax income for a year, in addition to home confinement and 24-hour GPS.
Okay, but so let's do it in this case, because he doesn't have a lot of financial information from your client, right?
Correct, although the burden is on the trial judge, according to this court's decision in Brangen, to ascertain that information. While I certainly concede it's
but again,
better practice to present it.
So how should the judge have done it differently in your case?
You should have begun by saying, Mr. Walsh, what amount of bail can you afford to post?
And he's going to say nothing, right?
Well, maybe, or maybe he'll say $100. Maybe he'll say, if you put me on home confinement with GPS for 24 hours a day, you're going to know exactly where I am every day and every moment. And anytime a probation officer calls me and says, are you still there? Yes. And don't forget you have a court hearing tomorrow. Yes, I'll be there.
I suspect your brothers in the next case may not be so fond of that, but go ahead.
Well, I mean, it's certainly not a negligible imposition on somebody, but we're now talking about a man who's been held for a year and a half, So, I mean, the deprivations of liberty and the consequences that flow from them are well documented by the amicus. They have negative consequences in individual cases and negative societal consequences from holding people before trial. So as a result,
but again, in this case, the judge finds, your client has worked in the past. He's been a construction worker. I don't know what it means on the big dig, but he's worked in the past. He's not, he lives, as you say, modestly. What would you, how exact is this in the real world? Can they be?
I think you need to find, and the Commonwealth needs to prove, that pretrial detention is the only mechanism that can ensure this person's return to court in the event that the court does not
Now,
find them
your
dangerous.
client's previously escaped from jail, right? He's facing serious time. I can't remember, has he not shown up in the past, the warrants
He had a
out for him?
25-year-old default, and that's exactly why we need better findings here. So the man's 60 years old. So when he was 35, he didn't show up for a court hearing. That was removed several years later. He had an attempted escape in the 80s. So I'd like to see a judge, before they deprive someone of their liberty for a year and a half pre-trial because they're finding that no other mechanism can return them to court, to explain why that 25-year-old history means that there is literally nothing other than being locked in jail for a year and a half that can ensure he comes back to court. And that's the implication of the court's holding in Brangen, is it's a deprivation of liberty, and the due process standards that apply kick in.
Well, but that's not the standard. I mean, first of all, the step one, I think you'll agree, is that the recommendation for bail from the Commonwealth is a recommendation for amount reasonably necessary to assure the appearance. That's the number we expect to get from the Commonwealth.
That's the number we're trying to navigate towards, for sure.
Right, and that's what the Commonwealth recommendation.
Well, what's the basis
obligation
of
of
their
their-
recommendation is
Right.
something that I think the court needs to explore. And
I'm getting at something that I think it's mentioned in Brangen, that the request is one that the Commonwealth believes is no more than is necessary to assure the appearance.
Right.
And then and then the judge decides what that number is. It's not that pretrial detention is required to assure their appearance. It's that there's a certain amount of bail that's required, and if that bail cannot be met, that we understand the reasons so it satisfies constitutional requirements.
Well, I mean, I do take a different view of Brangen. I feel that Brangen is really a case about pretrial detention.
don't.
And
That's
it's-
why I asked the question.
And there's two different standards that apply depending on whether the amount that's selected is going to result in pretrial detention or is it going to result in release. Because if it's going to result in release, you're in a broad discretionary context. And this is why the assessment of financial resources is so important. Because if the judge doesn't understand the number that's actually going to result in detention, the judge doesn't understand whether he or she is making a bail decision or a detention decision. And if it's a detention decision that's being made, then a whole bunch of due process protections that don't necessarily apply if the result of the proceeding is going to be release kick in. And
Yeah,
that's,
I understand. In a sentence, you're trying to infuse the Salerno protections in if it's a bail that can't be made.
I think that clear and convincing evidence standard is appropriate anytime somebody's deprived of liberty. I don't think that the basis being dangerousness or flight risk should change the calculus when it comes to the fact that the person is facing a loss of liberty either way. But what I also think is that clarity is needed about whether the particular order that's being imposed by the court and whether the particular amount that's being sought by the Commonwealth is intended to result in detention, or is it intended to be an amount that somebody has figured out a sweet spot that it can incentivize a return to court because you don't want to sacrifice that amount, but that you can still put that up and carry on with the rest of your life. Because we're not looking to handicap and damage people who are pre-trial and still enjoying the presumption of innocence. I mean, I think that's really what's going on here, is that you have over-detention. It's always easy to over-detain, right? You know they're coming back to court then, but no one's looking at the terrible collateral consequences that are happening from all these serial pretrial detentions.
How does the judge get to that sweet spot?
Well, the first thing, as I said, is
You ask the defendant, how much can you afford?
Ask the defendant,
And-
but you can also
and
look
he
at the
says-
probation
he says
report.
He says $50.
all right, so let's say he
Right,
says
say
$50.
He says $50 in every case.
And then
Could
you
he
could
be
say,
a fool
well,
not
I
to
see
say
that you've got an income of under, say, $25,000. You live in a household with 3 people. Tell me what your rent is. Tell me what your household expenses are. Let me understand the situation you're actually in so that we can figure out a way and to say, Mr. and Ms. Defendant, our goal here is to make sure that you come back here. right?
Should there be a more search and inquiry at the inception during the intake as far as one's
I mean, I certainly
financial-
think one way to facilitate this overall process would be to have probation gather more detailed information. I mean, it's already reasonably detailed, but they could take household budget down. And again, this is only going to pose a question when detention becomes a factor. And another thing we talk about in our brief that I think the court should really reiterate is that let's assume for a second the judge is not intending to detain, but an amount that's posted is too high so the person can't make it. After 2 weeks, you need to return that person to court and have the judge either say, wow, I miscalculated the amount, so we're either going to reduce the amount so you can make bail and still return to court. Or I'm going to say, actually, I acknowledge that I've imposed a pretrial detention order, and now we're going to get into the due process requirements that come along with that type of action.
But I'm not sure I follow the intention, because we have to assume the judges are doing what they're saying, in the sense they're intending to make sure the person shows up. They're not intending to detain. So I'm not, you may think of those as one and the same, but I don't think we have judges out there intending to detain when they're using this. They're intending to set a number to make sure the person shows up, right? And you're not going to certainly find them saying they're intending to violate the law, are you?
Oh, I don't think they're intending to violate the law, no. I think that I want to hear them say, this is what I expect to happen when I impose this number of bail. Either I expect to see you posted and walk out the door, or I expect to see you staying in the house of correction, because I know, based on everything I've looked at, you probably can't afford it. And the reason that I'm putting that in is that I don't think there's any other way to get you back to court, because if there is another way to get you back to court, then that's what we have to do, consistent with due process.
But aren't they, I mean, is that really going to result in something productive? Because they're going to say that that number is not intending to, is meant, because it's the number, I think, to make sure you show up.
Right, and so what we want to get to is a point where if they say that, and then 2 weeks later the person is detained, remains detained, they come back to court, and the judge says, oh, now I see I effectively put in place a de facto detention order. I didn't intend to that. I just wanted to create a number that you would say, wow, I don't want to lose that $1,000. I don't want to lose that $500. So I'll make sure I show back up, because bail is supposed to be an incentive, right? I mean, if we think about what the common law of bail is about, it's an incentive to show up. It's not a crushing liability that holds you in place and subjects you to all sorts of pretrial deprivations, right? I mean, that's not the goal.
That in your view would still hold true if, and this is unfortunately something that people see in court every day, someone who can't afford $500, can't afford $80, $50.
No, I mean,
right?
one of the really
if you let me
sobering things
if you
we
let
see
me-
is-
If you let me finish my
Oh,
question.
yeah, I'm sorry.
It takes a little while.
I'm
But
all
no,
hyped up.
no, you have someone who unfortunately can't afford any amount of bail, but, you have a BMC, a district court judge, they come in front of you, and the probation officer says, well, you look at the record, they've got 15 defaults in the last, 3 years. They just don't show up, and probably because of a number of problems, but you have someone like that. So a judge sets $100 of bail, which would be nominal to most, but not to some.
Sure.
And then 2 weeks later, the person still can't come up with $100. They're unfortunately
So I do
detained.
th- I mean, if you
So
have
what happens there?
Well, I think if a person with 15 defaults in the last 3 years, you could certainly imagine a judge conducting the analysis and saying there is no other way to return you to court. So if that finding is made, that finding can be entered and it can be reviewed, and perhaps it will be upheld. But,
Okay, so
given-
you're saying that in that situation, with the extreme that I'm painting of numbers of defaults, in someone who's really impoverished, they probably could be held on their $50 until the termination of their case.
I think they could if there was sufficient findings made to support the conclusion that there's no other way to return them to court. And if a person is obviously a serial defaulter on court cases, that's a strong indication that there are risks for not showing up. But the vast majority of people don't fit into that category. And I just think with all the other, we've seen the terrible impacts that cash bail is having on people across the country, across the Commonwealth, in individual cases, at community-wide levels. And with all the other innovative methods that are out there, between text messages, lawyer reminders, there's terms of release that require a phone call into probation once a day. There's a million different ways to keep people looped in, right? So, if you determine that someone's flagrantly disregarding the requirements, that's one thing. If a person's life is so chaotic that they literally can't keep track of a hearing in 3 months, a different mechanism, and one that does not cause further harm to their family and their community, is probably the way to go. And I would say due process requires us to go that way when we can.
So if I can make sure that I understand what you're asking us to do in terms of the set of findings you want a judge to make, okay? So what I think I understand from you is, first, you want a finding by the judge that the presumption of recognizance has been overcome, or
Yes.
not. Okay, so that's the first finding. Then assuming it has been overcome, you want the judge to examine whether there are non-cash conditions that would suffice.
Yes.
And if the answer to that is yes, then you don't get into bail. If the answer to that is no, you move into bail. And then you say, okay, now we're in bail world, and then you say to the defendant, or the judge says to the defendant, how much, given your ability to pay, can you afford as bail? Okay, and the person will give an amount, which may be the amount he can pay or she can pay, or arguably the amount that the parents or the uncle have agreed to put up, which could be more than the person could agree to pay. So, but let's assume they say $100.
Okay.
The judge in your world would then have to say, I think that's a fair amount, and that's the amount that I will impose, and then it's done because the person has said that he can afford. And if the
I don't think the
judge,
judge would be bound by.
not that bound, but the judge can say, okay, I'll do that, or the judge can say, no, that's not enough.
Sure.
Okay, so, and where the judge says that's not enough, then that means the judge would have to ascertain the ability to pay. So the judge would say, I think you can afford to pay more than that, and would then have to make certain findings as to the ability to pay.
Yes.
Correct? And then the judge would set an amount which the judge believes the person can afford to pay. Well, no, not necessarily. The judge can either then say, I think the maximum that you could afford to pay is X, but I don't, and either I'm going to impose that because I think you can pay it, or I think that's not enough. Correct?
And sure, I think, and it's not enough for one of two reasons. One is because you're being dishonest about how much you can afford, and the other is because I think an amount greater than you can afford is necessary because I think that's the only way to return you to court, in
Right,
which
but-
case we're really not setting bail, we're detaining.
Right, but if it's the first category, I'm basically saying, I don't believe you, I believe you can afford to pay X, and in my world, I'm not holding you for an amount beyond the amount that you can make because I believe you can make it.
Okay.
But it's only if you're saying, if I say, okay, I believe you can only pay $300, but I think I think $1,000 is the minimum necessary to assure your appearance. And when you do that, then you would say, then the judge would have to make findings by clear and convincing evidence that there are no other conditions. It's only there that the clear and convincing standard would kick in?
Yes, when a judge ascertains the amount that he or she believes the defendant can pay, decides to go over it, and states that the reason is that there's no other sufficient way to ensure the defendant's return to court. On the other hand, if the judge says, I think you can pay $300, and the person says, oh, I can only make one, and they go out and they're taken to the House of Correction, and 2 weeks later they come back and they're still sitting there, the judge can say, okay, well, either I was incorrect or I actually am holding you pretrial, and the reason for that is X, Y, Z. And if the judge can make those findings, the hold will go on, presumably a bail petition will be taken, and we can figure out if it was done constitutionally or not.
Okay, because you're saying essentially that there are two different avenues. The judge can say, I'm imposing this amount, and I believe that you can afford to pay it, or I'm imposing this amount, and I recognize that you can pay it.
Right, and this is why I'm really advocating for a burden on the Commonwealth, because the Commonwealth is the party seeking bail, right? So let's ask the Commonwealth to say, well, is this bail because we need to incentivize a return to court, or is this bail because the flight risk is such that only detention will return this person to court? Prove that.
And you're saying, just let me make sure, so if you pursue this avenue, the judge says, I think you can afford to pay it, your 2-week reconsideration is to essentially say, Judge, I think that you miscalculated about my ability to pay. It would not prevent the judge then from saying, okay, you're right, it turns out you can't afford to pay, but I still believe that this amount is necessary. And then the judge would have to make findings that I know you can't afford to pay,
Yes.
but there are these
But
reasons.
this is why this number is justified.
Okay, so
And moving us from the discretionary bail setting context into the due process necessary for the further an important government interest context.
But you would want us in part to separate the judge who says, I think you're full of baloney and you can afford to pay more, and therefore I'm imposing an amount which I believe you can afford to pay, as opposed to the judge who says, I recognize that you can't afford to pay this amount, but this is the amount necessary, and I recognize that this is effectively detaining you. And then you say the judge's findings would need to be based on clear and convincing evidence.
That is what we say.
That's what you're saying.
But I'm
sorry, Justice
confused, what is, so your client is, to follow just the conversation we just had, he says I can only pay 100.
Okay.
The judge says, I think it's gonna take 1,000 to make sure you show up. and we're in a land where your client hasn't provided much information, which is in almost all of these cases.
Right.
It's very difficult to determine what their actual income is, particularly because if we're dealing with someone who's accused of drug dealing, we don't know whether their income is actually from an illegal enterprise. What happened? What do you have to prove by clear and convincing evidence? So the judges set it at 1,000. You come in and say, the judge just set it at an amount my client can't make. We have very little information about what that amount actually is. What is the clear and convincing evidence standard? How are we going to apply it, and how are judges going to do this in the real world?
This is why I'm asking the court to require the Commonwealth to prove that detention is necessary, because that's what would be proved.
No,
by
no,
clear
but
and
the
convincing
Commonwealth, you keep saying that they're proving detention is necessary. The judge is saying $1,000 is necessary to make sure he or she shows up. And the Commonwealth is saying there's support for that.
And
I'm just trying to understand
what
how.
imaginary support would there be for a number that bears no relation to the defendant's actual income or assets?
Well, but we don't know, we don't have any real sense of what that number is.
Well, this is why the 2-week waiting period that we're suggesting
And
will
that's
prove
why-
so much, right? Because presumably a person could be a drug dealer and have $100,000 buried in a can in the backyard. If so, after a couple of weeks in the House of Correction, they're probably going to want to get back to their life and they'll come up with the money. But if not, it's much more likely that what's actually happening in most of these cases is that the judge has picked a number from who knows where, and it's not something that the person can afford. And so that despite the fact they'd like to get back and start preventing their life from continuing off the rails, they're going to have to sit in the House of Correction for a year and a half, increasing the likelihood of conviction, longer sentence, losing their home, all these other things. So we really need to be tuned into the harms that are at issue and put processes in place that are attuned to those harms, right? The one interest of the government here is returning somebody to trial. It is not imposing some sort of leverage to get a better case outcome. And I think, so if a judge comes up with a number, he or she should say, I calculated this number by reference to X, Y, Z factors. All right, thanks so much.
Wait.
Oh, yeah.
One more question.
I can stay all day.
No, we're not going to have you do that. We're not going to have you do that. With regard to the failure to appear, as opposed to a dangerousness hearing, the evidence is usually going to be right in the criminal history sheet. I mean, it's going to be defaults, escapes. That's going to be generally the basis for a judge to say, I'm looking at this, and given the history of defaults, or given the record of escapes, or given the fact that you're a fugitive.
Sure, just dangerousness hearings are often on the papers now, too, as a practical matter.
Right, but the dangerousness hearings, they're on the papers based on police reports, but generally, most of these findings are going to be based on the query.
Fair, yeah.
Okay. Now you can go.
Thank you so much.
Ms. Lazar.
Good morning. Ellen Lazar for the Commonwealth. Addressing first the so-called LaValle claims, there is no remedy warranted here because any delay in the appointment of counsel for these defendants was remedied as soon as a judge learned of it. There have been no hearings delayed due to the delayed appointment of counsel since December of 2018, and no defendants were detained following hearings at which they were unrepresented by counsel. LaValle simply does not apply in this case because the court in LaValle created a protocol to address what was an ongoing and systemic violation of rights, which does not exist in this case. In addition, that protocol was a means to achieve the appointment of counsel, which was the ultimate goal. It was not a means to simply achieve the release of defendants or the dismissal of their cases. Here, as soon as a judge became aware that these defendants were held without counsel, counsel were appointed. As Justice Kafker noted, CPCS made significant changes that alleviated the problems that arose last year in Worcester. And there have been no delays in the appointment of counsel or no delays in hearings due to the appointment of counsel since, as I said, at least December.
But was it error for the judge to signal out a particular CPCS supervisor? Should the judge have just directed this to CPCS itself? I mean, it's sort of a strong arming, and I understand it's effective when your name's on it, but That's not proper, right? It should have been to CPCS, right?
Yes, I think under the statute, the judge is supposed to assign the case to CPCS, and then CPCS appoints a particular attorney. And in this case, the cases had been assigned to CPCS. In one case, actually, an attorney had been appointed, but for some reason, he did not appear at the hearing, whether it was
So is
because...
that, at least at the first line, because they're going to, creative work by CPCS solved the problem this week. I take it we're going to come back to at least the borderline fairly soon. Is the first line of defense that judges should, basically direct CPCS? We can't allow the 7 days to pass. We can't allow the 45 days to pass. You need to take immediate measures, right? That should be the first step? And
Right, and presumably CPCS also would...
we can't wait 6 months to get to us and order LaValle again, right?
No, and I will say too, though, that in this case, unlike in LaValle, it's just simply not so clear that there's just not the clear record of systemic deprivations of counsel that we had in LaValle. As Judge Kenton Walker found, based on her review of these hundreds and hundreds of pages of documents and affidavits that were submitted to her, it's not clear how many defendants actually were unrepresented, how many hearings were delayed, or for how long, due to the unavailability of counsel, as opposed to for other reasons, like a delay in the Bar Advocate Program being informed that counsel were needed, or even the request of counsel for a delay. So that's another reason why here the LaValle Protocol simply doesn't fit, or it doesn't fit in the sense of it's not sort of a standing order that's a protocol that's just out there. And anytime there's an allegation that the appointment of counsel was delayed, the protocol kicks in. As Chief Justice Gantz noted, this is a much more broad and somewhat burdensome administrative protocol where many things have to happen, many people have to get together, information has to be gathered, there's a process to be followed. None of that happened here. All the defendants asked for was, hey, I was held for more than 7 days, I didn't have counsel, you should release me. And it's the Commonwealth's position that that is not what LaValle says. It is not just a freestanding order for release. It is a means to achieving the appointment of counsel, and that was achieved here.
So let me ask you the same question I asked your brother. How do you define a crisis? How do you define something which would trigger LaValle?
I do think that whether it's a defendant or defense counsel or a judge in Worcester, let's say, petitioning a single justice of this court to say, we believe that we're at a point right now where perhaps something like the LaValle Protocol is required, and then findings are made and the affected parties are brought together to weigh in. A determination is made that that so-called crisis point has been reached, and a protocol is put into effect, which may or may not be exactly the same as LaValle. That was appropriate at that time, in that place, in those circumstances, and I don't think that it's a one-size-fits-all remedy every time there's a delay or an alleged shortage in the appointment of counsel.
So what do we, your office has doubled the number of dangerousness hearings, which it's entitled to do, but that, of course, doubles the burden on CPCS with regard to finding counsel in order to represent individuals. What happens when it turns out that the well has run dry and that they simply are not able, at the rate that is currently being paid available, to be able to timely provide counsel for a dangerousness hearing?
Well, first, Your Honor, I would say that it doesn't necessarily equate to doubling finding attorneys because, for instance, among Judge Kenton Walker's findings were the facts that in district court, unless they are bind-over felonies, counsel are generally appointed on the day of arraignment. They represent defendants at those dangerousness hearings, and that the majority of cases that then come to the Superior Court on dangerousness hearings, those same attorneys who've already represented the defendant in district court tend to continue to represent them in Superior Court. So it's not simply a case where, one more dangerousness hearing in Superior Court necessarily means the addition of one additional attorney.
But you've increased the number of dangerousness hearings in district court, too.
Yes,
considerably.
but there were no delays of any hearings in district court as a result of the unavailability of counsel. This was only occurring in Superior Court as a result of there being a shortage of people who were certified by CPCS or the Bar Advocate Program to represent people in Superior Court.
Right, but it's a dramatic drop in Superior Court
Yes.
in terms of the numbers,
Yes,
even though Superior Court attorneys are being paid more than district court attorneys.
yes,
And it's also a dramatic drop, not only in terms of the number of attorneys who are agreeing to take Superior Court cases, but also in terms of the number of those attorneys who are taking fewer or no Superior Court cases.
that's correct.
So it's not as if we don't have a problem here. We may not have a problem that has risen to the level right now of a crisis, but what do we do in a situation? What do we do where essentially we have a dangerousness hearing and CPCS says, I simply can't find an attorney who is willing to take the case? So what do we do?
Well, Your Honor, I think first, obviously, I don't disagree that there was a shortage of attorneys who are certified to practice in Superior Court.
You're saying was, you're saying it's past tense?
Well, in Worcester County, at this time, I use the word shortage to mean at this moment, they have enough attorneys to cover the number of cases that they have.
But you agree
But
that
I
the number of
understand.
Superior Court, persons agreeing to take Superior Court cases has dramatically dropped.
Yes.
And that's an is, not a was.
Yes, and I do know that my understanding is that CPCS is in negotiation or speaking to the legislature about trying to get more funding, increasing the funding, the amount that they pay these attorneys to encourage more attorneys to take on these cases. And so I know that that is one potential remedy, which obviously is out of our hands. In terms of the case-by-case, how to handle on a case-by-case basis, if there literally were no attorneys, if there's a particular case, let's say in this case, and the case came before the court, the Commonwealth was ready to proceed, there were literally no attorneys who could take the case for the defendants, then certainly I think a judge would have to consider what her options were, and among those might be releasing a defendant who's unrepresented. But attorneys were found for these defendants, and by the time the defendants even filed their 211-3 petitions in this court, they had attorneys, they've been represented since that day, they had had their dangerousness hearings, and again, shortly after that time, based on whatever changes had been made, there were no more delays in any hearings based on the appointment of counsel.
But
So,
I'm concerned systemically that it may come back. And let me a couple of questions I asked that didn't come back with the findings that there wasn't information about. Just a preliminary question before I get into that, though. One of the issues is that there are lawyers who take appointments in the district court who also are certified for Superior Court, but because of the limit of hours, they have some reticence or inability to take Superior Court cases because of the hours they're putting in the district court, correct?
I know that there are limits on the number of hours. I believe there's a limit of 1,650 hours total, and that after 1,350, they're not permitted to take any new cases.
And if you don't have more hours available, even if you're certified for Superior Court, you have to wonder about an appointment day in Superior Court.
Yes.
So it's entirely an executive branch prerogative of how often to request 58 days. But it's also an executive branch prerogative in the district court for the DA to say, we're not going to be seeking jail time on this operating after suspension case. And well, my experience is a long time ago. It was very infrequent when I would ask the DA if they were going to ask for jail time in this case, when I didn't think they would, the answer would be, yes, we will, or we might. Very unusual for the DA to say that. So there wasn't a need for counsel to be appointed. So is it part of the executive branch when you have, the disorderly conduct that you know you're never going to ask for jail time on, to let the judge know proactively that we're not going to be seeking jail time on this case, because it's imperative and constitutional and important for too many reasons to list. We need to have vigorous counsel for criminal defendants. The constitutional requirement, I believe, is those that might face committed time.
Yes, Your Honor, and I know that that was one of the questions that you asked Judge Kenton Walker to address, and she did address it, although briefly, because the answer was no, that there's no formal policy, that the district attorney's office does not have a formal policy about informing judges. And I would imagine that it happens, sort of anecdotally. Yes, judges may ask the particular ADA, are you planning to seek jail time? And the ADA may say yes or no, depending upon the particular facts of the case, but there's no formal policy regarding that.
Well, I guess I was suggesting in the question, just like it's an entirely executive branch prerogative to move for 58A, it's also an executive branch prerogative to decide whether or not you're going to be seeking jail time on this trespass case with somebody who might have been impaired or for whatever other reason. The dynamic process on how many hours are available for a conscientious bar advocate.
Yes, it's true, Your Honor. And as I said, I'm sure that there are cases in which the ADA informs the judge we're not seeking jail time, but I just know that there's no formal policy governing which cases that those may be, because of course there may be other considerations, such as the prior record of the person, not simply the single crime that's in front of the court on that day. And so there's no formal policy on that, although, as I said, I'm sure that it does happen.
You don't like LaValle being used as sort of an off-the-rack solution when we get into trouble here. But given how close we are to trouble, what do you recommend we do then? Just leave it to sort of the jumble that, out there, or should we have some kind of protocol that will kick in when this, because this is going to keep coming because we're so close to this problem each time. And with LaValle in place, there seemed to be a backup, but you don't like LaValle as a backup, so what should we do?
Well, it's not that I don't like it as a backup. Well, I guess it is that I don't like it as a backup in the sense that, again, I don't believe it's just sort of a standing order. And if someone decides, hey, we're in a crisis, all of a sudden LaValle kicks in.
Right, but we know, a month from now or 2 months from now, if your office keeps doing the number of dangerous and serious, which is your prerogative, and CPCS doesn't get the raise from the legislature, which is their prerogative, we're going to be back here. I'm just trying to understand, because it seems like we need LaValle in there to step in, but do you want us to tweak LaValle? There's this Missouri approach where you triage cases that one of the council recommended, or is LaValle the best of the bad solutions if this kicks back in?
It's not that I think the LaValle protocol is useless. I think that it just doesn't sort of arise of its own force. I think that certain findings have to be made, and I do think that it should be with the supervision probably of a justice of this court, based on this court's power to supervise all of the courts, rather than, again, let's say one judge in one district court says, hey, you know what, I think that there's a crisis. Can that judge just suddenly start imposing this protocol? I just think that there needs to be someone
as you pointed out, by the time it got to us, the people who originally brought the case had attorneys and their situations were resolved. So how do we fix it so that when it arises, whatever we just determine it is, what should we do? What should happen? We can't wait until it gets here every time.
But the point is that it was fixed. I mean, the point of LaValle isn't, hey, let's all engage in this protocol and release people and dismiss people's cases. The point of LaValle is let's get people lawyers. And in Worcester County, people got their lawyers. And so if that is the goal, that's what was achieved. So my point is just that the LaValle, there was no cause for using that protocol in Worcester County because the goal of the protocol to get people lawyers was achieved.
So you're saying that it's LaValle or bust, there's nothing else that we have to worry about?
No, I'm saying that in appropriate circumstances, if either a judge or a defendant or someone senses there's a shortage, or there's a shortage happening now, there's a shortage on the horizon, I think this is happening again. Someone alerts a justice of this court, for example, and brings together the players who will be affected by these determinations.
But just to play that out a little bit, so again, this crisis, 2 weeks from now, when this happens again, the judge says, just what you say, let's get some lawyers, orders CPCS to provide some lawyers. CPCS says we're all maxed out. Comes to Justice Budd again. Isn't she going to just put LaValle into place, or do you not want us to do that? Because we have to act quickly.
Right, and perhaps she will. Perhaps she will say, give me the information that I need to determine, yes, I think here there is a crisis. Maybe instead she'll say, you know what, CPCS, I hear what you're saying, but I don't agree. I think you could do X, Y, and Z.
But can the trial judge do that? I mean, can the trial judge order CPCS to provide lawyers? If CPCS says I don't, can the trial judge, him or herself, impose LaValle without calling the single justice of the SJC to do that? Is that a better solution, or you don't like that solution much?
Well, again, if you look at...
Or give a modified LaValle?
I think I would hesitate to have just one trial judge deciding, hey, I'm going to impose LaValle. Again, is it a Superior Court judge? Is it a District Court judge? Is it one out of the 11 district courts in Worcester? So I do think at the very least it should be someone in more of a supervisory position that can oversee the process. But again, then determinations have to be made, whether it's by the Raj or this particular trial judge or this court, that CPCS has made its best effort to find attorneys. And so I think, again, it's not just well, I've been held for 7 days, I should be released. It is much more, it entails much more than that. There has to be a showing and fact-finding and bringing people together. And there were a list of, I think, about 10 different parties who were involved in these weekly meetings in LaValle, where they would review how many people were unrepresented. And maybe there should be a determination of priority, whether it's the length of time or the seriousness of the charges or whatever it is. But I think that although it's a good framework, there does have to be some analysis on a case-by-case basis of whether it fits each particular situation. And again, most importantly, that it doesn't just arise of its own force, that findings have to be made that it is appropriate to use this in this case, again, with the ultimate goal being the appointment of counsel, not the ultimate goal being release or dismissal.
But if we can distinguish between what you and I have called the protocol of LaValle versus the hammer of LaValle, I mean, I understand you to say that the protocol, which requires meetings on a weekly basis and going overall, I understand your view that that should not be imposed by a single trial court judge, that that should be something which we or a single justice should do. But we still have the situation of the judge herself. And I sat in Worcester, so I understand. So let's take me back to the glory days where I'm sitting in Worcester as a Superior Court judge, and we have a case, and you move for dangerousness, and I appoint CPCS to represent the indigent defendant, and CPCS says, Your Honor, we can't get anybody to do it. And the 7 days are approaching. So what do I do?
I think that the judge in those circumstances, again, not necessarily even having anything to do with LaValle, could say, okay, this person is deprived of his right to counsel. CPCS, I want you to reach out to Boston, I want you to do this, that, and the other thing. If none of those things work, then certainly the judge would have it in his or her discretion possibly to release the defendant or come up with some other remedies. Just based on remedying a deprivation of this person's rights, separate and apart from any protocol in LaValle in the individual case.
So you're saying the protocol of LaValle would require SJC involvement, but the sanction of LaValle, that is, if there can't be counsel found despite good faith efforts after 7 days, the person has to be released from custody, that's something which a trial court judge could do.
I think a judge probably could do that, and Judge Kenton Walker did consider it in this case, but alternatively, she appointed these two attorneys, and then ultimately successor counsel were found, and they remained in the case. So again, I think it's something that,
But doesn't that sort of turn the prioritization of LaValle on its head? Because LaValle, in the end, says the most important thing is to get counsel. So we're going to end up releasing rather than getting counsel? It just seems like that's a little
no,
backwards.
I mean, certainly, Your Honor, I'm not advocating for release of defendants who are held pending dangerousness hearings. But my point is just that if the question is, well, wait, it takes a while to get the LaValle protocol in place, what are we to do? I think that judges do have some amount of discretion. I think, again, in this case,
They continued the hearings in
Right.
violation of the statute, right, but they continued the hearings.
well, I wouldn't agree it was in violation of the statute. It says, except for good cause shown, it may not be continued beyond this period of time. I would argue that good cause is finding attorneys and allowing them to have enough time to prepare to handle dangerousness hearings. And so, again, in this case, attorneys were found, the hearings were continued, the hearings were held, and they've been represented ever since. So certainly, I'm not saying, yeah, just release people rather than putting the LaValle protocol in place. My point is just that,
But in response to the Chief's question, you said the trial judge has the authority maybe to release, but he doesn't have the authority, or she doesn't have the authority to set in place the protocol. It just seems, that seems a little problematic, because the protocol is meant to avoid the sort of sanction. And in LaValle, they didn't like dismiss the cases, right? I can't remember what the actual result was in LaValle.
in LaValle, either someone held more than 7 days without counsel could be released, or someone not
I
held.
understand the protocol, but I can't remember what the result was in that particular, were there individuals in that case? It wasn't just an abstract ruling, right?
Oh, no, there were, I think, maybe dozens of people total who had been actually detained after hearings that were conducted without counsel.
Right, but the remedy wasn't to dismiss their cases without prejudice. The remedy was they got counsel fast enough, so there was nothing done.
I don't know in LaValle if any of those people ended up being released or if their cases were dismissed. I mean, the case itself set forth the protocol and then sent everyone back to implement it. So I don't know what the results were for those particular defendants. And no, certainly, as I said, I'm not advocating that a judge should release a defendant rather than trying to find counsel. The point of LaValle is obviously to find counsel for these defendants, but I do acknowledge that at some point, if counsel can't be found and a defendant's rights are being violated, that is something that needs to be remedied, whether by putting that protocol in place, but even under the protocol, ultimately, if all of the, 10 players who have an interest in the matter are brought together and CPCS asserts that they've made their best effort to find counsel and counsel still can't be found, then release is one of the options, or the option, if there's no counsel and a person is still held. So I'm just acknowledging that that may be something,
Do you want to address the bail?
if you'd like me to. As to the claims
You
regarding...
could do it briefly.
Yeah, briefly. Well, it's the Commonwealth's position that the court need not set any additional requirements for judges setting bail beyond what is already required by Brangen and now also by statute. As the court is obviously aware, in Brangen, the court stated that if a judge is setting bail, that someone is likely to be unable to post, the judge has to make findings of fact and a statement of reasons, including how the bail was calculated and why the risk of flight is so great that no alternative condition will assure the defendant's presence. And then the bail statutes were also amended to add an additional requirement, which is an explanation why the Commonwealth's interest in bail outweighs any adverse impact on the defendant and his or her family.
Now, in GP, for a Section 35 hearing, we said that given the loss of liberty, even though it is no more than 60 days, I believe, that the minimum standard was clear and convincing, that was a due process requirement, where a judge determines that I'm imposing a bail that is above the amount the person is going to be able to afford to pay, and the result will be detention that could be longer than 60 days, and often is. Why is the due process clause not also require at least clear and convincing?
I think because the purpose of the bail order is not to detain the person. The purpose of the bail order is to assure the person's return to court. I think that's why
the consequence is, the Brangen says, at some point you recognize that you are detaining the person, and you need to come to grips with that and make findings appropriate to it. So it may not, yeah, but you are detaining the person.
I think part of the reason, too, why it's more appropriate to keep the preponderance standard is because most of the financial information is going to be in the defendant's possession, not the judge's, not the Commonwealth's. And even in a case, if you use this case as an example, the judge said that the defendants provided him with very little financial information, even though he requested more information about one of the defendant's employment status. It wasn't given to him. They didn't ask for any more time to gather any more financial information. The defendants didn't suggest any sort of particular bail amount that they thought that they could pay. But then the judge still, of course, has to make a determination of what he thinks is necessary to get them back to court. And when he sets this bail amount, the defendants complain that he didn't give enough of a detailed analysis of their finances to support his determination. So I think that because the information is mostly in a defendant's possession, you're sort of putting a judge in a position of like, heads I win, tails I lose. If I don't.
But that's why I, in questioning Mr. Schnipper, bifurcated the decision that says, I believe this is an amount you can afford to pay. That, I think, at least I understand him to say, that's a preponderance decision. It's only when you say, I am now imposing an amount which I recognize you cannot afford to pay, then only then must it be by clear and convincing evidence.
Well, as Your Honor noted, I think generally, if the judge is saying, I'm imposing this amount despite that I recognize that you may not be able to pay it, and the reason that I'm imposing it is I think it's necessary to get you back to court. Much of that information is going to be in the record before the court, things like defaults or escapes or the history, the person's criminal history, if they have, the seriousness of the charges, the sentences that they may face now. And so most of that information is going to be in the possession of the court anyway through the probation department. And I would also note that I think adding on to this process, the types of processes that the defendants are asking for really threatens to kind of bring arraignment sessions to a halt. Because even though the defendant is saying, well, it need not be onerous, they can just go to the indigency form filled out by a defendant at intake. On the other hand, they're asking for full-blown evidentiary hearings, adversarial hearings with a right to present witnesses and a right to cross-examine witnesses. And although the defendants say, well, we won't have to have that in every case, we'll only have it in cases where judges may be setting bail that's unaffordable, this court recognized in Brangen that because a judge may not know if the bail is unaffordable, a judge, in most cases where a judge is setting an amount of bail, should make these findings. So as a practical matter, what we're looking at is a full-blown evidentiary hearing in every case where a judge is considering bail. And if you look at the thousands of cases that are obviously being arraigned and bail considered across the Commonwealth, I think that that would just bring the entire system to a halt if...
Cause a Lavallee problem.
Exactly.
But, put aside it's going to come down to looking at the query.
And it may, and so
I
really.
mean, put aside his call for an evidentiary hearing, the risk of flight is generally going to be reflected in the four corners of the query, as well as any information that the prosecutor may be able to say about a prior record of escape, or we found him in New Mexico, we had to bring him back. Put aside the evidentiary hearing, why is it burdensome to say it's clear and convincing standard to apply when I'm basically using the query to determine that there's a concern about flight?
Because I think it's not only the flight piece, it's also the financial piece that the defendants
He's
would
already
ask
decided
for.
he's already decided I'm imposing an amount that I know the person cannot afford to pay. So the financial piece is already done. Now the only issue is whether or not the risk of flight justifies detention.
Well, I think, again, because this court has stated that bail hearings are meant to be sort of somewhat straightforward, not evidentiary hearings, not akin to a sentencing or a restitution, and that slightly lower level of proof, especially where it is evidence that's generally just in the possession of the probation department, or, again, to the extent there has to be any financial information considered in the possession of the defendant, that the preponderance standard is just more appropriate for what the bail hearing is intended to be.
And your concern is when the defendant says, I can afford $50, and the judge sets $2,000, the next case is going to be, well, I didn't have a robust opportunity to rebut that. I needed more information. How did the judge come up with $2,000? Because we have just some indigency form and the defendant's assertion they can only afford $50. A judge has to make a determination that requires evidence, and that requires a delay. That's
Right.
going to result in a delay.
Right. And also, I mean, in the end, the setting of bail is a discretionary matter. Now, of course, if it appears that a defendant might be unlikely to afford the bail, it's also guided very strictly by Brangen and by the bail statutes, but it is also an exercise of discretion. And so this court.
It's an exercise of discretion, but we've got a presumption of release, so there's a limit to the discretion, isn't there? And then that creates a finding issue where it's very difficult to articulate those reasons in terms of how do you know how much will assure somebody to return. I mean, it's very complicated, though, even though it's
Right. It is.
supposedly not.
Right, it is complicated, and it's an exercise of discretion, but it is also guided and bound by what this court said in Brangen and what it now says in Section 57 and 58. And so I think what this court said in a Juvenile versus Commonwealth after Brangen is that the judge's findings, statements of reasons, need to demonstrate that a judge engaged in a fair and meaningful consideration of reasonable alternatives relevant to the circumstances, such that a reviewing court can be satisfied that the requirements detailed in Brangen have been met. And so I think that is the appropriate standard, that it doesn't have to be, some of it will be somewhat implicit. As Justice Gaziano noted, if a judge is setting bail, it's sort of implied that a judge found that release on recognizance is not appropriate in that case.
What do we make of the statistic cited by your brother about 40% are being detained? I mean, that's a troubling statistic, right? And I take it 40% the judges aren't making findings that I've found that this is more than you can pay, right? I suspect I don't know if that was in the study, but I suspect it's a much smaller percentage, right?
And I don't know, I was about to say, I think those are two different things. Saying that 40% of people who had this amount of bail set were held, and there's a sort of a leap to assume that the judges in those 40% of cases didn't make the findings that they were supposed to make. And if they didn't, of course, at any time, it can be brought back in front of the judge for further findings, or a bail review can be taken and it can be remanded for further findings. And so I wouldn't just assume that because that number of defendants are held pretrial, that automatically means that the judge did not engage in the appropriate analysis or make the appropriate findings to justify his or her decision. I don't think that we can assume that every time a defendant is held pretrial, that it means that the judge did something wrong.
Okay, thank you.
Thank you.